Taking up the case of People in the State of Michigan versus Dustin May Sutton. This is file number 25-14050. FH, addresses, please.
Good morning, Your Honor. Aaron House on behalf of the people.
Thank you, Your Honor. Patrick Cherry on behalf of Mr. Sutton, who is present.
We are here for a sentencing on a conviction involving a plea to 3 counts of criminal sexual conduct in the 3rd degree.
The prosecutor and I have been in communication, so I guess I'll address all of them. That way we can sort of streamline this. I believe we're in agreement that on all 3 counts, OB12 should be scored at 0 points, bringing the total OB to 95. Does not change the scoring, and that's because conduct scored in OBs 11 and 13 cannot be scored in OB12.
I understand.
And I'm in agreement with that, Your Honor.
We'll go ahead and strike offense variable 12 from 10 points to 0. That changes the total from 105 to 95 for each of the 3 counts.
For prior record, it has 1 felony conviction, 1 misdemeanor conviction, former probation, and former parole. Those should all be zeros and nos, because this offense occurred prior to all of the subsequent.
Yeah.
And there is no argument that there were subsequent offenses, just that this should be.
And I'm in agreement with that also, Your Honor. Thank you.
Mr. Stapleton, you got all that?
I did, yes.
All right.
The time that Mr. Sutton served between October 4th, 2016 and January 25th, 2017, he was serving a sentence under another case, and so he does not get credit for that.
For the
113 days.
Yep. All right. Thank you. I actually had a question mark there. So.
And that is correct, Your Honor. Just, for the record, Mr. Stapleton and I have had contact with the court out in Washington and confirmed that that was related to his subsequent sexual assault when he was arrested for, but had nothing to do with this case, and there was no extradition going on. I've also checked, just for the record, with the Michigan State Police. They have no record of that, and the Wexford County Prosecutor's Office has no record of ever being contacted about that.
Thank you. Mr. Cherry, next.
PFA 284, page 1, under weaknesses. So we'd ask that the last sentence be stricken, as this is a first offense.
I think for the fact that this report will follow him through the prison system and be reviewed by the parole board, I think it should be accurate. So I think it should just be clear that it was subsequent.
All right, Mr. Stapleton, go ahead and make that change. Okay. I understand that the victim of the case wishes to make a statement.
She does, right?
All right, she may come forward. All right, ma'am, for the record, please state for me your first and your last name.
Isabella Keithley.
Yes, ma'am. What is it you'd like to say today?
Sorry.
It's okay. Take your time.
I would just like to say thank you for doing all this. Thank you to my attorney for doing this for me. It's been 11 years that I've dealt with this. 10 years I was sexually abused for my life, and I spent the next 11 years trying to deal with that on my own, without any justice for myself, because I never got an answer. I never was told anything. And for 11 years, I thought the justice system didn't care. I thought the legal system didn't care at all. And he went on to hurt more people. And that's what hurts me the most, is that it didn't stop with me. It continued on to hurt multiple people. And he's just a danger to women. He's a danger to society in general and to children. You should never touch children, let alone physically hurt them. And yeah, I just want to make it clear that he is dangerous to women. Even though it may not look physical, it's very mental after a certain point.
Sure, I understand.
So, but thank you.
All right, ma'am. Thank you very much, Isabel. You may take your seat. Thank you. I'll just go ahead and allow allocution from Ms. House. Ms. House?
Yes, thank you, Your Honor. What the defendant did to the victim was a horrible violation and betrayal of her. She was a vulnerable young person, and he came into her home as a guest in her home and then proceeded to, provide her with alcohol and then sexually molest her on multiple occasions. And he seemed to have almost no remorse for it, in that he sort of talked about it proudly with her in these text messages. It was an excellent investigation by Trooper Moore with the state police, and then an excellent interview out in Washington where he ended up admitting to all of this conduct. And then what's incredibly disturbing to me is he admitted to that conduct in October, and then he sexually assaulted a sleeping victim in December of that same year. So there is great concern about what he's done. I respect the fact that he pled guilty to all three of these charges, that he is taking ownership of it now, this many years later. I think that that's important for the victim. It's just been really important that this needs to come to light. And it's just a highlight to me of how often the court system, inadvertently fails victims. The state police did an excellent investigation. The prosecutor's office charged this case right away, but then because the defendant was living out of state, he was just allowed to get away with this and continue to perpetrate on other people for many years. And this victim was left feeling like what happened to her didn't matter. And that people who were in positions of authority, who were supposed to listen to her and believe her and protect her and get justice for her, just didn't do anything, weren't able to do anything. And so I recognize it is expensive and complicated to extradite people. And so I'm just grateful that we have a project now through the Attorney General's office with the U.S. Marshal's office that we're able to apprehend people that are dangerous like Mr. Sutton and provide a sense of closure and justice to the victim in this case and the victim in so many cases who deserved more from the system. So she has been consulted all along. I have met with her more than a half dozen times. We've talked on the phone many times. She has been very involved in this process. She supports this, both the plea agreement and the sentence agreement. As the court sees, it is in the middle of the guidelines. It is a fair agreement in this case. I think it does take into account that the defendant did choose to plead guilty, did not make her go through a trial in this case, and I give him a small bit of credit for that. And I would ask the court to follow the agreement that we've made and to get closure for the victim in this case.
Thank you. Mr. Chairman?
A few things. I'll start with a slight correction just because I want to make sure the court considers it. Offense 2, which is the CSC in Washington, the offense date was October 4th. The interview with Mr. Sutton was October 20th. So he didn't commit the offense after the interview. The interview was after this offense. It was actually an interview that corresponded to that offense.
Okay.
So,
all right.
So it wasn't that he gave the interview and then went out and did something.
All right.
Okay. Mm-hmm. Number 2, I want to make sure, and I think all the parties agree to this. Mr. Sutton, in his mind, was not absconding. He didn't know there was a warrant in Michigan. And so I want to make sure that the court isn't taking into account that he failed to turn himself in for a period of years. He just didn't know that this warrant was out there for him. Mm-hmm. In fact, at the time of his arrest, he was working, had a home, was doing the things that he should have been doing. Obviously, this isn't a thing that he should have been doing. But for those reasons, I think that the plea agreement along with the Killebrew agreement do take those things into account. And I think that Ms. House was generous in calling it the middle of the guidelines. I would consider this a bottom of the guidelines agreement. It's kind of potatoes, but I think it takes into account all of those things. There were not reduced charges as part of the plea agreement, so he's not receiving a benefit that way. And so the small benefit that he is receiving, I think, is the 6 years out of what the guidelines could be for him. Thank you, Your Honor.
All right. Thank you. Mr. Sutton, you have the right to make a statement if you choose to do so. Is there anything you wish to say at this time, sir?
Yeah, I would just like to say that I was a foolish, lonely young man. I can only apologize for what I've done. I've tried to live a better life since then, but I didn't know they weren't worth here. I would have shown up and did my time because it is a terrible thing I've done. And all I really have to say.
Thank you.
Thank you, sir.
And I do sincerely thank you for that. And I highlight for the victim. You don't often hear that in the courtroom. Not often in these cases do people make an apology in this situation. In fact, most of them And if many don't plead guilty, they plead no contest, so they never make the admission in a courtroom. So you have gotten an admission and an apology. And by the way, I know none of that makes the scars go away or makes the impact go away, but for whatever it's worth, I thank Mr. Sutton for making those statements. And a trial can be very difficult. Oh, thank you. I look at this because I have a different perspective from everyone else here as far as the military connection. I have absolutely no idea why that court-martial convening authority, in other words, the commander for Fort Lewis, did not take this case. If you're a military service member, you are subject to the jurisdiction of the Uniform Code of Military Justice anywhere your body can be, including outer space. So, whatever it is. Why they didn't take it, beyond me. I'm really quite curious if they knew about it. By the way, local police officers don't always think about that, but it looks like police officers out in Washington, someone knew about it. If you're a police officer or agency outside of a military base, you know, take it to the military. Because even if the acts occurred here in Michigan, it's okay, they can court-martial a person. And you never would have gotten an honorable discharge, it would have been a dishonorable discharge. And in the military, Uniform Code of Military Justice, the sentencings run consecutively. They are aggregate. So you'd be facing up to 45 years. But actually, in the military, the maximum punishment's a lot higher, but still the point is they would all run consecutive to one another. So the fact that it didn't get picked up for whatever unknown reason is a huge benefit to you. Now to Miss Keating. Keatley, I'm very sorry, ma'am. Miss Keatley. Very sorry you had that gap in time. I was the prosecutor not when these charges came about, before I took this bench. Had I known the case was sitting there in my shelves, I would have had somebody call and let you know what the status was. But the prosecutor's offices and the police agencies are busy. Not to say your case wasn't valuable. Please don't take anything like that away. Unless there's some system to keep reminding, hey, you've got these other 200 cases sitting here while you're still dealing with your other 400 cases currently going on. That's not a good excuse, but it's just to kind of explain to you. When you charge a case, it sits there and you wait and you work on all the other cases, chop all the other wood until that person gets picked up. So it's very unfortunate that you did not have somebody to go to, all right, to ask this question. Anyways, I'm very sorry that you had that delay. Well, I know this case has an agreed upon Killebrew sentence to 6 to 15. Find here based upon the absconder status is the fact that he picked up a couple offenses while elsewhere in the country, had a personal protection order. Another offense involved indecent liberties, which seems to be very similar to these offenses here. Definitely that this sentence is reasonable and proportionate. Again, I'm surprised. I know Mr. Che was in the service. I retired as a JAG officer. I've been a prosecutor, a defense attorney, a senior defense attorney, an appellate attorney, and a judge and a magistrate and an instructor. Have no idea how they did not pick this case up. It would have been an easy case. And when I was a prosecutor, I always had my court-martial convening authority informed of every case that came off, even from out in the civilian world. So there's been a benefit to you, Mr. Sutton, because of that. Court assesses $368 state minimum fee, the $130 crime victims right fund fee. We're going to say a $300 court cost, a $500 fine, a $300 attorney fee. Do I need to do DNA fee? Well, did he have a DNA fee back in, well, he probably didn't have one because he wasn't arrested here. So there should be a DNA order. If not, we'll make sure we get one signed, and that'll be payable to the Washington County Sheriff Department since he'll be in it. Well, at least until he's in the jail. No supervision fees because there's no probation. There will be a prison sentence pursuant to the pretrial agreement. That will be 72 to 180 months. Anything else, Ms. Howe?
Just if the court would order that he have no contact with him.
The court will put a no contact order in, make that a term. Well, no, I'll have to add that it's not a term of probation. Madam Clerk, you can just probably put that in the other line at the bottom of page 2. Thank you. Ms. Keatley, and best of luck to you. I hope that with this is be able to bring you some closure in some sense, and wish you the best of luck as well. We are adjourned.
I think you're on.